Question 1. During the evaluation of a complex dispute involving a divorcing couple in Alabama, where the husband also seeks to resolve outstanding business partnership dissolution issues with the wife, what is the most appropriate mediation approach for the mediator to adopt? Option A. Treat the entire dispute as a single mediation, focusing on overarching settlement principles that can be applied to both the family and commercial aspects to achieve a comprehensive resolution efficiently. Option B. Conduct separate mediation sessions for the family law matters and the commercial partnership dissolution, clearly outlining the distinct procedural expectations and applicable legal frameworks for each context to the parties. Option C. Apply the procedural rules and ethical considerations typically used in commercial mediation to the entire dispute, emphasizing contractual obligations and financial settlements. Option D. Prioritize resolving the commercial partnership dissolution first, as it may provide financial clarity that could simplify the subsequent family law mediation. The correct answer is B. Conduct separate mediation sessions for the family law matters and the commercial partnership dissolution, clearly outlining the distinct procedural expectations and applicable legal frameworks for each context to the parties. Explanation. This scenario presents a professionally challenging situation because it requires the mediator to navigate the distinct legal and emotional landscapes of family and commercial disputes simultaneously, while adhering to Alabama's specific mediation rules and ethical guidelines. The challenge lies in maintaining neutrality and ensuring appropriate procedural safeguards are applied to each distinct context. Careful judgment is required to avoid conflating the principles and practices applicable to each type of dispute, which could compromise the integrity of the mediation process and the enforceability of any agreements reached. The best professional approach involves recognizing the fundamental differences between family and commercial mediation and tailoring the process accordingly. This means understanding that family mediation in Alabama often involves sensitive issues like child custody, support, and division of marital assets, which are governed by specific Alabama family law statutes and court rules regarding mediation. It necessitates a mediator skilled in addressing emotional dynamics and power imbalances inherent in family disputes. Conversely, commercial mediation in Alabama typically focuses on contractual obligations, business disputes, and financial matters, governed by Alabama contract law and commercial statutes. A mediator must be adept at facilitating discussions around business interests and legal precedents relevant to commercial transactions by dedicating separate sessions, or at least distinct phases within a joint session, to each context, and by clearly outlining the different procedural expectations and applicable legal frameworks for each party. The mediator upholds their duty of impartiality and ensures that the mediation is conducted in a manner consistent with Alabama's legal and ethical standards for each specific area. This approach respects the unique requirements of each dispute type and maximizes the likelihood of a fair and durable resolution. An incorrect approach would be to treat both the family and commercial aspects of the dispute as a single, undifferentiated mediation. This failure to distinguish between the contexts would likely lead to a superficial examination of critical family law issues, potentially overlooking the best interests of children or the nuances of marital property division, which are paramount under Alabama law. Furthermore, it could result in a commercial resolution that is improperly influenced by emotional family dynamics, or vice versa, undermining the objective assessment of business interests. Such an approach risks violating ethical obligations of competence and diligence by not applying the appropriate legal and procedural knowledge to each distinct area of dispute. Another incorrect approach would be to apply the procedural rules and ethical considerations of commercial mediation to the family law aspects without modification. For instance, focusing solely on economic efficiency and contractual remedies, as is common in commercial disputes, would be inadequate for addressing the complex emotional and relational issues central to family law matters in Alabama. This could lead to agreements that are legally sound from a commercial perspective, but fail to adequately protect vulnerable parties or the welfare of children, contravening Alabama's public policy in family matters. A third incorrect approach would be to prioritize the resolution of the commercial dispute over the family dispute, or vice versa, without a clear agreement from all parties. This would demonstrate a lack of neutrality and could lead to one party feeling pressured or disadvantaged, compromising the voluntary nature of mediation. Alabama mediation rules emphasize impartiality and the right of parties to control the outcome, and such a prioritization would violate these core principles. The professional reasoning process for a mediator in such a situation should begin with a thorough intake and assessment of all parties and the nature of their disputes. The mediator must identify the distinct legal and emotional components of the case. They should then clearly communicate to all parties the different mediation processes, ethical consideration, and potentially applicable legal frameworks for each aspect of the dispute. Obtaining informed consent from all parties regarding the proposed mediation structure is crucial. The mediator must then be prepared to employ different techniques and knowledge bases appropriate for each context, ensuring that all relevant Alabama laws and ethical standards are respected. Continuous self-monitoring for impartiality and a commitment to facilitating a fair process for all parties, regardless of the dispute type, are essential. Question 2. Research into the Alabama mediation process indicates that during a contentious property dispute, one party becomes visibly distressed, crying and expressing feelings of being overwhelmed and unfairly treated. As the mediator, what is the most appropriate immediate response to ensure the mediation remains productive and ethically sound? Option A. Acknowledge the party's distress with empathy, briefly validate their feelings, and then gently redirect the conversation back to the specific issues and options for resolution, reminding them of the mediation's purpose. Option B. Offer personal advice and comfort to the distressed party, suggesting ways they might cope with their emotions outside of the mediation session. Option C. Continue with the agenda as planned, ignoring the emotional outburst to maintain focus on the legal and factual aspects of the dispute. Option D. Urge the distressed party to compose themselves quickly, stating that their emotional display is hindering the progress of the mediation for everyone involved. Correct answer is A. Acknowledge the party's distress with empathy, briefly validate their feelings, and then gently redirect the conversation back to the specific issues and options for resolution, reminding them of the mediation's purpose. Explanation. This scenario presents a professional challenge because the mediator must navigate a delicate situation where a party's emotional state could significantly impede the mediation process, potentially leading to an impasse or an unfair outcome. The mediator's duty is to facilitate a voluntary and informed resolution, which requires careful management of the party's emotions while upholding the integrity of the process. Alabama law, particularly as it relates to mediation ethics and the Alabama Center for Dispute Resolution Standards of Professional Conduct, emphasizes impartiality, voluntariness, and the mediator's role in managing the process, not dictating outcomes. The best approach involves acknowledging the party's distress and gently guiding them back to the issues at hand, while ensuring they understand their right to pause or withdraw. This aligns with the mediator's ethical obligation to ensure parties are participating voluntarily and are capable of making informed decisions. By validating the party's feelings without getting sidetracked by them, and by reiterating the purpose of mediation, mediator can help de-escalate the situation and refocus the parties on problem solving. This technique respects the party's emotional experience while maintaining the structured nature of the mediation process, as envisioned by Alabama's ADR framework. An incorrect approach would be to ignore the party's emotional outburst, proceeding as if nothing has happened. This fails to acknowledge the human element of dispute resolution and can alienate the distressed party, making them less likely to engage constructively. It also risks violating the mediator's duty to ensure voluntary participation, as a party overwhelmed by emotion may not be truly consenting to the process. Another incorrect approach is to become overly involved in the emotional distress, offering personal advice or attempting to counsel the party. This crosses the ethical boundary of mediator neutrality and impartiality. Mediators are facilitators, not therapists, and engaging in such behavior compromises their role and the integrity of the mediation process, potentially leading to a biased outcome or a perception of bias. Finally, an incorrect approach would be to pressure the distressed party to continue despite their emotional state, perhaps by suggesting they are delaying the process. This is coercive and directly contradicts the principle of voluntary participation, a cornerstone of mediation ethics in Alabama. It can lead to an agreement that is not genuinely consensual or a breakdown of trust in the mediation process. Professionals should employ a decision-making framework that prioritizes understanding the emotional dynamics of the parties, assessing their impact on the process, and employing techniques that manage these dynamics while upholding ethical obligations of neutrality, voluntariness, and procedural fairness. This involves active listening, empathetic acknowledgement, and skillful redirection back to the substantive issues, always respecting the party's autonomy. Question 3. System analysis indicates that a mediator in Alabama is facilitating a dispute between a small business owner with extensive legal knowledge and an individual who has limited experience with business contracts and legal proceedings. The individual expresses a desire to settle quickly to avoid further stress and cost, and the business owner presents a settlement offer that appears financially advantageous to the business owner, but may not fully address the individual's underlying concerns or potential future liabilities. What is the most appropriate course of action for the mediator in this situation? Option A. Pressure the less experienced party to accept the offer by emphasizing the significant financial and emotional costs they will incur if the dispute proceeds to court. Option B. Accept the settlement offer immediately, as the primary goal of mediation is to reach a resolution, and the business owner's offer appears to be a swift and financially beneficial outcome for them. Option C. Advise the less experienced party on what they should accept, suggesting that the business owner's offer is reasonable given the circumstances and the potential costs of litigation. Option D. Facilitate a discussion where both parties can fully articulate their concerns, explore the implications of the proposed settlement, and ensure the less experienced party understands the terms and potential consequences before reaching any agreement. The correct answer is D. Facilitate a discussion where both parties can fully articulate their concerns, explore the implications of the proposed settlement, and ensure the less experienced party understands the terms and potential consequences before reaching any agreement. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing the client's immediate desire for a swift resolution with the mediator's ethical obligation to ensure the process is fair and informed. The mediator must navigate the power imbalance and potential for undue influence without overstepping their neutral role. Careful judgment is required to facilitate communication and understanding, while upholding the integrity of the ADR process as envisioned by Alabama law. Correct approach analysis. The best professional practice involves the mediator facilitating a discussion where both parties can express their concerns and understand the implications of the proposed settlement. This approach aligns with the principles of Alabama's mediation statutes, which emphasize voluntariness and informed consent. The mediator's role is to ensure that the parties are making decisions freely and with a clear understanding of the terms and consequences, particularly when one party may be more vulnerable or less informed. This includes encouraging open dialogue, clarifying misunderstandings, and ensuring that the agreement reached is fair and equitable under the circumstances, without imposing their own judgment. Incorrect approaches analysis. One incorrect approach involves immediately accepting the settlement offer simply because it resolves the dispute quickly. This fails to uphold the mediator's duty to ensure the process is fair and that the agreement is informed. Alabama law expects mediators to facilitate a process where parties understand their rights and obligations, not merely to expedite closure at any cost. This approach risks an agreement that may be later challenged due to coercion or lack of understanding. Another incorrect approach is for the mediator to advise the less experienced party on what they should do or what a fair outcome would be. This crosses the line from facilitation to advocacy, violating the mediator's fundamental duty of neutrality. Alabama's ADR framework mandates impartiality, and providing advice undermines the party's autonomy and the integrity of the mediation process. A further incorrect approach is to pressure the less experienced party to accept the offer by highlighting the potential costs and delays of litigation. While informing parties about potential consequences is part of a comprehensive mediation, using this information as leverage to force an agreement constitutes undue influence. The mediator must ensure that any decision is voluntary and not the result of pressure or intimidation, as mandated by ethical guidelines and the spirit of Alabama's ADR statutes. Professional reasoning. Professionals should approach such situations by first assessing the power dynamics and information asymmetry between the parties. The mediator's primary responsibility is to ensure a fair and informed process, which may involve spending more time clarifying issues, encouraging open communication, and ensuring both parties have a reasonable understanding of the proposed resolution and its implications. If a significant imbalance persists and cannot be mitigated through facilitated discussion, the mediator may need to consider whether the mediation can proceed ethically or if further steps are necessary to ensure fairness. Question 4. Operational review demonstrates that a client, a manufacturing company based in Alabama, has entered into a contract with a supplier located in Canada for the provision of specialized components. The contract contains a clause stipulating that any disputes arising from the agreement shall be settled by arbitration in accordance with the rules of the International Chamber of Commerce (IC), with the seat of arbitration to be in Birmingham, Alabama. Supplier, facing a dispute over payment terms, has indicated a willingness to engage in arbitration, but has also threatened to initiate litigation in a Canadian court if their demands are not met promptly. The client, concerned about the potential costs and complexities of international arbitration, is seeking advice on how to best respond to the supplier's threat and ensure their contractual rights are protected under Alabama law. Option A. Advise the client that the arbitration clause is binding and enforceable under Alabama law, and that any attempt by the supplier to litigate in Canada would likely be stayed in favor of arbitration in Birmingham, Alabama, as per the parties' agreement and Alabama's commitment to international arbitration conventions. Option B. Suggests that the client ignore the arbitration clause and attempt to negotiate a settlement directly with the supplier, without formally acknowledging the arbitration agreement, to avoid the perceived complexities of arbitration. Option C. Advise the client to agree to litigate the dispute in the Canadian court, as this may be a more familiar forum for the supplier and could potentially lead to a quicker resolution. Option D. Recommend that the client immediately file a lawsuit in an Alabama state court to preemptively address the dispute, arguing that the ICC arbitration rules are overly burdensome for a contract of this nature. The correct answer is A. Advise the client that the arbitration clause is binding and enforceable under Alabama law, and that any attempt by the supplier to litigate in Canada would likely be stayed in favor of arbitration in Birmingham, Alabama, as per the parties' agreement and Alabama's commitment to international arbitration conventions. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a dispute between parties from different jurisdictions, necessitating an understanding of international arbitration principles and the specific legal framework governing such agreements in Alabama. The core challenge lies in determining the enforceability and procedural validity of an arbitration clause when one party attempts to circumvent it, requiring careful consideration of Alabama's adoption of international arbitration conventions and its domestic arbitration statutes. Correct approach analysis. The best professional approach involves recognizing the binding nature of the arbitration agreement as stipulated by the parties' contract and Alabama law, which generally favors the enforcement of arbitration clauses. This approach would involve advising the client that the dispute must proceed to arbitration as agreed, and that any attempt to litigate in an Alabama court would likely be dismissed in favor of arbitration. This is correct because Alabama has adopted the Uniform Arbitration Act, and for international arbitrations, is a signatory to the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention, both of which strongly support the enforceability of arbitration agreements. The principle of party autonomy in choosing arbitration as their dispute resolution mechanism is paramount. Incorrect approaches analysis. One incorrect approach would be to immediately file a lawsuit in an Alabama state court, arguing that the arbitration clause is invalid or unenforceable due to perceived procedural irregularities in the underlying contract. This is incorrect because it disregards the explicit agreement to arbitrate and the strong public policy in Alabama favoring arbitration. Such an action would likely be met with a motion to compel arbitration, leading to wasted time and resources, and potentially sanctions for frivolous litigation. It fails to acknowledge the legal framework that prioritizes the enforcement of valid arbitration agreements. Another incorrect approach would be to advise the client to ignore the arbitration clause and proceed with litigation, hoping the other party will not pursue arbitration. This is professionally unsound and ethically problematic. It undermines the integrity of contractual agreements and the established legal mechanisms for dispute resolution. It also exposes the client to significant risk if the other party does enforce the arbitration clause later, potentially leading to unfavorable outcomes due to procedural delays or adverse rulings. A further incorrect approach would be to attempt to negotiate a settlement outside of the arbitration process without first addressing the enforceability of the arbitration clause. While settlement is often desirable, proceeding without acknowledging the agreed-upon dispute resolution method can create complications. If negotiations fail, the party attempting to litigate would still face the hurdle of the arbitration clause, and any prior litigation attempts could be viewed negatively by an arbitral tribunal. Professional reasoning. Professionals facing such a situation should first meticulously review the arbitration agreement to confirm its validity and scope. They should then consult the relevant Alabama statutes, including the Alabama Uniform Arbitration Act, and any applicable international conventions if the arbitration is international in nature. The primary professional duty is to advise the client on the legal enforceability of the arbitration clause and the consequences of either pursuing or circumventing it. The decision-making process should prioritize adherence to contractual obligations and the established legal framework for arbitration, guiding the client towards the most legally sound and strategically advantageous path, which in this case is likely arbitration. Question 5. Operational review demonstrates that during a mediation session in Alabama concerning a contentious divorce, one party makes a statement indicating a serious intent to harm their spouse. The mediator is aware of the strong confidentiality protections afforded to Alabama mediation proceedings. What is the most appropriate course of action for the mediator? Option A. Carefully assess the nature and imminence of the threat. Consult with the parties regarding potential disclosure if the threat is serious and immediate, and if necessary, disclose only the information required to prevent harm to the appropriate parties or authorities, documenting the decision. Option B. Ignore the statement, assuming it is hyperbole and not a genuine threat, and continue with the mediation as if no such statement was made. Option C. Immediately disclose the statement and the intent to harm to the spouse without any further discussion or assessment. Option D. Disclose the statement to the spouse's attorney, believing it is their professional responsibility to inform legal counsel. The correct answer is A. Carefully assess the nature and imminence of the threat. Consult with the parties regarding potential disclosure if the threat is serious and immediate, and if necessary, disclose only the information required to prevent harm to the appropriate parties or authorities, documenting the decision. Explanation. Scenario analysis. This scenario presents a common challenge in mediation, balancing the mediator's duty of confidentiality with the potential need to disclose information to prevent harm. The mediator must navigate the strict confidentiality rules governing Alabama mediation, while also considering ethical obligations and potential legal ramifications if harm is not addressed. The professional challenge lies in interpreting the scope of confidentiality and identifying exceptions without overstepping boundaries or breaching trust. Correct approach analysis. The best professional practice involves the mediator carefully assessing the nature and imminence of the threat. If the threat is serious and immediate, the mediator should consult with the parties regarding the potential disclosure, explaining the limited circumstances under which confidentiality might be breached according to Alabama law and ethical guidelines. If the parties cannot agree, or if the threat is so severe that immediate action is required, the mediator should then consider disclosing the information to the appropriate authorities or individuals, documenting the decision-making process thoroughly. This approach prioritizes the safety of individuals while respecting the mediation process and its confidentiality as much as possible, adhering to the spirit and letter of Alabama's confidentiality statutes and mediation ethics. Incorrect approaches analysis. One incorrect approach would be to immediately disclose the information to the spouse without any consultation with the parties. This violates the fundamental principle of confidentiality in Alabama mediation, which is crucial for fostering open communication and trust. Unless a specific, legally recognized exception applies and has been carefully considered, such a disclosure would breach the mediator's ethical and legal obligations. Another incorrect approach would be to ignore the statement entirely, assuming it is not a serious threat and therefore not subject to any exceptions to confidentiality. This fails to adequately assess the potential for harm and could have severe consequences if the threat materializes. Mediators have a professional responsibility to consider the implications of statements made during mediation, especially those indicating potential harm to self or others, and to act in accordance with Alabama's legal and ethical frameworks for such situations. A third incorrect approach would be to disclose the information to the spouse's attorney without the spouse's consent or a clear legal mandate. This also breaches confidentiality and could undermine the mediation process. Alabama law generally requires consent for disclosure, and mediators must be acutely aware of the specific exceptions and their limitations. Professional reasoning. Professionals should approach such situations by first understanding the specific confidentiality provisions of the Alabama Mediation Act and relevant ethical codes. They should then engage in a risk assessment of the disclosed information, considering the severity, imminence, and credibility of any potential harm. If a potential exception to confidentiality is identified, the mediator should consult with the parties, if feasible and safe, to discuss the situation and potential actions. If disclosure is deemed necessary and legally permissible, it should be limited to the information required to address the threat and directed to the appropriate parties or authorities. Documentation of the entire process, including the assessment, consultations, and any actions taken, is essential for professional accountability. Question 6. Operational review demonstrates that during a mediation session in Alabama concerning a property dispute, one party expresses significant hesitation about a proposed settlement agreement, stating they feel pressured and unsure if it is truly in their best interest, despite the other party's apparent satisfaction. What is the most ethically sound course of action for the mediator? Option A. Advise the hesitant party that the proposed settlement appears reasonable given the circumstances and the time invested, encouraging them to accept it to conclude the matter. Option B. Immediately suggest specific amendments to the settlement proposal to address the parties' perceived pressure, without further consultation with both parties on the direction of these changes. Option C. Acknowledge the parties' concerns, reaffirm the voluntary nature of mediation and the right to withdraw, and offer to explore their reservations further in a way that does not pressure them towards any specific outcome. Option D. Inform the hesitant party that their concerns are not objectively valid, and that they should proceed with the agreement to avoid further complications. The correct answer is C. Acknowledge the parties' concerns, reaffirm the voluntary nature of mediation and the right to withdraw, and offer to explore their reservations further in a way that does not pressure them towards any specific outcome. Explanation. This scenario presents a professional challenge due to the mediator's dual role as a facilitator of communication and a guardian of the integrity of the mediation process. The mediator must navigate the potential for a party to feel coerced or unfairly influenced, which directly implicates ethical duties of impartiality and voluntariness. Careful judgment is required to uphold the fairness and effectiveness of the mediation. The best approach involves the mediator acknowledging the parties' concern about the proposed settlement, reiterating the voluntary nature of mediation, and offering to explore the parties' reservations further, without imposing any judgment or pressure. This upholds the ethical principle of self-determination, ensuring that any agreement reached is genuinely voluntary and informed. Alabama's ethical guidelines for mediators emphasize impartiality and the right of parties to withdraw from mediation at any time. By offering to explore concerns and reaffirming voluntariness, the mediator respects these principles. An approach that involves the mediator strongly advising the party to accept the settlement, citing the perceived fairness or the time already invested, fails to respect the party's autonomy. This crosses the ethical line of impartiality and can be seen as pressuring a party, undermining the voluntary nature of the agreement. Mediators are not advocates for any particular outcome. Another unacceptable approach is for the mediator to dismiss the party's concerns outright, suggesting they are being overly emotional or unreasonable. This demonstrates a lack of impartiality and empathy, potentially alienating the party and damaging the trust necessary for effective mediation. It also fails to address the underlying issues that might be causing the parties' hesitation. Finally, the mediator unilaterally suggesting modifications to the settlement without further discussion with both parties, even with good intentions, can be problematic. While exploring options is part of mediation, doing so without ensuring both parties are comfortable with the direction or have had a chance to voice their perspectives can be perceived as biased or as the mediator taking too active a role in dictating terms, rather than facilitating agreement. Professionals should approach such situations by first actively listening to and validating the parties' concerns. They should then clearly and calmly reiterate the core principles of mediation, particularly voluntariness and self-determination. The mediator should then offer to facilitate a discussion to explore the concerns further, allowing the parties to address them directly or with the mediator's assistance, always ensuring that no party feels pressured into an agreement. Question 7. Which approach would be most effective for a mediator in Alabama when mediating a dispute between two parties with significantly different cultural backgrounds, where one party is accustomed to direct, assertive communication, and the other prefers indirect, nuanced communication, and both parties express a desire for a fair resolution? Option A. Focus solely on the legal merits of the dispute, treating cultural communication differences as secondary and not directly relevant to achieving a legally sound agreement. Option B. Rely entirely on the parties to explain their cultural communication differences to each other, with the mediator intervening only when direct communication breaks down completely. Option C. Actively inquire about each party's preferred communication styles and cultural norms, adapting mediation techniques to accommodate these differences while maintaining neutrality and ensuring both parties feel understood and respected. Option D. Assume that standard mediation techniques, emphasizing direct and assertive communication, will be universally understood and effective, encouraging both parties to adopt this style for clarity. The correct answer is C. Actively inquire about each party's preferred communication styles and cultural norms, adapting mediation techniques to accommodate these differences while maintaining neutrality and ensuring both parties feel understood and respected. Explanation. This scenario is professionally challenging because it requires the mediator to navigate deeply ingrained cultural differences that can significantly impact communication, perception of fairness, and the very definition of a successful resolution. The mediator must remain neutral while acknowledging and respecting these differences, ensuring that neither party feels marginalized or misunderstood due to their cultural background. Failure to do so can lead to an impasse, a perceived unfair outcome, or a breakdown of trust in the mediation process itself. The best approach involves actively seeking to understand and incorporate the cultural perspectives of both parties into the mediation process. This means the mediator should inquire about communication styles, decision-making processes, and underlying values that may be influenced by culture. By demonstrating a willingness to learn and adapt their own approach, the mediator can build rapport and create a safe space for open dialogue. This aligns with the ethical principles of mediation, which emphasize impartiality, self-determination of the parties, and the mediator's responsibility to facilitate a process that is fair and accessible to all participants, regardless of their cultural background. Alabama law, while not explicitly detailing cultural competence in mediation, implicitly supports these principles through its emphasis on fairness and the voluntary nature of mediated agreements. An approach that assumes all parties share similar communication norms and expectations, or one that attempts to impose a single, dominant cultural communication style, is professionally unacceptable. This can lead to misinterpretations, frustration, and a feeling of disrespect, undermining the mediator's neutrality and the parties' willingness to engage constructively. Such an approach fails to acknowledge the diversity of experiences and perspectives that parties bring to mediation, violating the spirit of inclusive dispute resolution. Another unacceptable approach is to ignore or downplay the cultural differences, treating them as irrelevant to the dispute. This can result in the mediator overlooking crucial underlying issues that are deeply rooted in cultural values or practices, leading to superficial agreements that do not address the core of the conflict. This failure to recognize and address the impact of culture can result in a mediation process that is not truly fair or effective for all parties involved. Finally, an approach that relies solely on the parties to educate the mediator about their cultural norms without the mediator actively seeking to understand and integrate this information is insufficient. While parties can offer insights, the mediator has a professional responsibility to be proactive in developing their cultural competence and applying it to the mediation process. The professional decision-making process for similar situations should involve a commitment to ongoing learning about cultural diversity, a willingness to ask open-ended questions about cultural influences on the dispute, and a flexible approach to mediation techniques that can accommodate different communication styles and values. The mediator should prioritize creating an environment where all parties feel heard, understood, and respected, ensuring that the process itself is culturally sensitive and promotes equitable outcomes. Question 8. Investigation of a dispute arising from a mediated settlement in Birmingham, Alabama, reveals that one party is refusing to comply with the terms of the signed mediation agreement, claiming it is not binding because they felt pressured into signing and did not fully grasp the implications of a specific clause regarding future business dealings. The mediator, who facilitated the session, is now being consulted. What is the most appropriate course of action for the mediator to advise regarding the enforceability of the agreement? Option A. Suggest that the party who feels pressured seek independent legal counsel to challenge the agreement's validity, without offering any opinion on the agreement's enforceability yourself. Option B. Immediately declare the agreement unenforceable due to the party's expressed feelings of pressure and lack of full understanding, as this indicates a lack of genuine consent. Option C. Advise the parties that since the agreement was signed at the conclusion of a mediation session, it is presumed to be a binding contract, and the refusing party must comply. Option D. Advise the parties to review the agreement to determine if it contains clear terms, evidence of mutual assent to those terms, and consideration, as these are the fundamental requirements for contract enforceability under Alabama law. The correct answer is D. Advise the parties to review the agreement to determine if it contains clear terms, evidence of mutual assent to those terms, and consideration, as these are the fundamental requirements for contract enforceability under Alabama law. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a dispute over the enforceability of a mediation agreement, directly impacting the finality of the resolution process and the parties' rights. The mediator must navigate the delicate balance between encouraging settlement and ensuring that any agreement reached is legally sound and enforceable under Alabama law. The challenge lies in identifying the precise legal standard for enforceability and applying it to the facts presented, while also considering the ethical obligations of a mediator. Correct approach analysis. The best professional practice involves carefully reviewing the mediation agreement to determine if it meets the essential elements of a contract under Alabama law, specifically focusing on whether there was a clear offer, acceptance, consideration, and mutual assent to all material terms. This approach is correct because Alabama courts will enforce mediation agreements when they constitute valid contracts. The Alabama Code, particularly provisions related to contract law and the Uniform Mediation Act, if applicable and adopted in a way that impacts enforceability, guides this assessment. A valid contract requires a meeting of the minds on all essential terms. If these elements are present, the agreement is likely enforceable. Incorrect approach is analysis. One incorrect approach is to assume the agreement is automatically enforceable simply because it was signed by the parties at the end of a mediation session. This fails to recognize that a mediation agreement is still subject to contract law principles. Without a clear offer, acceptance, consideration, and mutual assent on all material terms, it may not be a binding contract under Alabama law. This overlooks the legal requirements for contract formation. Another incorrect approach is to disregard the agreement if one party expresses dissatisfaction or claims they did not fully understand a particular clause, without a thorough examination of whether that clause constitutes a material term, and if there was genuine misunderstanding or duress. This approach risks undermining the mediation process by allowing parties to unilaterally escape agreements based on subjective feelings rather than objective legal standards for contract validity. It fails to uphold the principle that agreements reached through voluntary participation should be honored if legally formed. A further incorrect approach is to advise one party on the likelihood of enforcing the agreement without first conducting a comprehensive review of the agreement's terms and relevant Alabama contract law. This crosses the ethical boundary of mediator neutrality and impartiality. Mediators should not act as legal advisors or advocates for either party. Their role is to facilitate the agreement, not to interpret its enforceability for one side over the other. Professional reasoning. Professionals should approach disputes over mediation agreement enforceability by first identifying the governing law, Alabama contract law, and any specific mediation statutes. They must then objectively assess whether the agreement contains the essential elements of a contract: offer, acceptance, consideration, and mutual assent to all material terms. If these elements are present, the agreement is likely enforceable. If there are ambiguities or potential defenses to enforcement, like lack of capacity, duress, or fraud, these must be evaluated against established legal principles. Throughout this process, maintaining strict neutrality and avoiding any action that could be construed as legal advice or advocacy for either party is paramount. Question 9. Assessment of a mediation agreement in Alabama reveals that the parties have included a clause stating they will engage in arbitration to resolve any disputes arising from their contract. However, The specific language does not explicitly define whether this arbitration is intended to be binding or non-binding. What is the most professionally responsible course of action for the mediator to take in this situation? Option A. Decline to proceed with the arbitration due to the ambiguity in the arbitration clause. Option B. Proceed with the arbitration assuming it is binding, given that arbitration clauses generally aim for finality. Option C. Proceed with the arbitration assuming it is non-binding, as this is a less restrictive form of dispute resolution. Option D. Facilitate a discussion with the parties to clarify their intent regarding binding versus non-binding arbitration, and ensure this understanding is documented before proceeding. The correct answer is D. Facilitate a discussion with the parties to clarify their intent regarding binding versus non-binding arbitration, and ensure this understanding is documented before proceeding. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the mediator to navigate the differing expectations and potential legal ramifications of two parties who have agreed to mediation, but have not clearly defined the nature of the arbitration clause in their underlying contract. The mediator must ensure that the process aligns with the parties' intentions and Alabama law regarding dispute resolution, particularly concerning the enforceability of arbitration awards. Misinterpreting or failing to clarify the arbitration type could lead to a protracted and ultimately unenforceable process, undermining the purpose of ADR and potentially exposing the mediator to ethical scrutiny. Correct approach analysis. The best professional practice in this situation is to facilitate a clear discussion with both parties to determine whether their arbitration agreement contemplates binding or non-binding arbitration, and to ensure this understanding is documented. This approach is correct because Alabama law, like most jurisdictions, recognizes both binding and non-binding arbitration, but their legal effects are distinct. Binding arbitration results in an award that is generally enforceable by courts, while non-binding arbitration serves more as a recommendation or advisory opinion. Alabama Code Title VI, Chapter 6, Article 10, Uniform Arbitration Act, governs arbitration in Alabama and emphasizes the importance of the parties' agreement. By clarifying the type of arbitration, the mediator ensures the process is conducted in accordance with the parties' mutual understanding and the applicable legal framework, thereby maximizing the likelihood of a meaningful and enforceable resolution. This proactive clarification upholds the mediator's duty to conduct the process fairly and effectively. Incorrect approaches analysis. One incorrect approach would be to proceed with the arbitration assuming it is binding simply because the parties mentioned arbitration in their contract. This is professionally unacceptable because it ignores the critical distinction between binding and non-binding arbitration. If the parties intended non-binding arbitration, proceeding as if it were binding could lead to an unenforceable award and a waste of the parties' resources. Furthermore, it fails to adhere to the principle of party autonomy, which is central to ADR, by imposing an interpretation without explicit agreement. Another incorrect approach would be to assume the arbitration is non-binding and simply provide a recommendation without confirming the parties' intent. This is also professionally unacceptable. While non-binding arbitration is a valid form of ADR, proceeding under this assumption without explicit agreement could frustrate the parties' desire for a potentially final and enforceable resolution. It bypasses the procedural safeguards and enforceability mechanisms associated with binding arbitration, which may have been their actual objective. Finally, another incorrect approach would be to refuse to proceed with arbitration altogether due to the ambiguity. While caution is warranted, outright refusal without attempting to clarify the parties' intentions is professionally deficient. The mediator's role includes facilitating dispute resolution. By failing to engage the parties in a discussion to resolve the ambiguity, the mediator misses an opportunity to fulfill their professional obligation and assist the parties in reaching a mutually agreeable and legally sound process. Professional reasoning. Professionals facing such ambiguity should adopt a structured decision-making process. First, identify the core issue, the unclear nature of the arbitration clause. Second, consult relevant legal frameworks, in this case, Alabama's Uniform Arbitration Act, to understand the implications of different arbitration types. Third, prioritize party autonomy and clear communication. Engage the parties in a direct conversation to ascertain their understanding and intent regarding the arbitration. Fourth, document the agreed-upon process clearly. If the parties agree on binding arbitration, ensure they understand the implications of enforceability. If they agree on non-binding arbitration, ensure they understand its advisory nature. This systematic approach ensures that the ADR process is conducted ethically, effectively, and in compliance with applicable law. Question 10. The control framework reveals that an arbitrator in Montgomery, Alabama, is scheduled to preside over a commercial dispute between two businesses. The arbitrator discovers that the claimant's lead attorney is a former law partner with whom the arbitrator maintained a close professional and social relationship for over a decade, though they have not practiced together for 5 years. The arbitrator believes this past relationship will not influence their judgment, but acknowledges it could be perceived as a conflict by the claimant's business opponent. The arbitrator is considering how to proceed. If the total potential damages in the dispute are $500,000, and the arbitrator's standard fee is $500 per hour, with an estimated hearing duration of 40 hours, what is the maximum potential arbitration fee the arbitrator could earn if the hearing proceeds and concludes as estimated, assuming no delays or additional complexities? Option A. The arbitrator should immediately disclose the relationship to both parties in writing, and if either party expresses concern or if the arbitrator believes impartiality could be compromised, recuse themselves. If the arbitration proceeds and concludes as estimated, the maximum potential fee would be $500 text hour times 40 text hours equals $20,000. Option B. The arbitrator should inform only the respondent of the relationship, as they are the party likely to perceive a conflict, and if the hearing concludes as estimated, the maximum potential fee would be $500 text hour times 40 text hours equals $20,000. Option C. The arbitrator should proceed with the arbitration without disclosure, assuming their professional integrity will prevent any bias, and if the hearing concludes as estimated, the maximum potential fee would be $500 text hour times 40 text hours equals $20,000. Option D. The arbitrator should disclose the relationship to both parties but proceed with the arbitration, believing their professional judgment is sufficient to overcome any perception of bias, and if the hearing concludes as estimated, the maximum potential fee would be $500 text hour times 40 text hours equals $20,000. The correct answer is A. The arbitrator should immediately disclose the relationship to both parties in writing, and if either party expresses concern or if the arbitrator believes impartiality could be compromised, recuse themselves. If the arbitration proceeds and concludes as estimated, the maximum potential fee would be $500 text hour times 40 text hours equals $20,000. Explanation. The control framework reveals a scenario where an arbitrator in Alabama faces a potential conflict of interest that could compromise the integrity of the arbitration process. This situation is professionally challenging because the arbitrator's impartiality, a cornerstone of fair dispute resolution under Alabama law and ethical arbitration standards, is called into question. The arbitrator must navigate this delicate situation with utmost care to uphold the trust placed in them and the arbitration system. The best approach involves immediate and transparent disclosure of the potential conflict to all parties involved. This entails informing both the claimant and the respondent, in writing, about the nature of the relationship with the claimant's attorney and the potential for it to be perceived as a conflict. The arbitrator should then recuse themselves from the case if either party expresses concerns, or if the arbitrator believes the conflict cannot be effectively managed to ensure impartiality. This proactive disclosure and willingness to step aside, if necessary, aligns with the ethical principles of arbitration, which emphasize fairness, integrity, and the avoidance of even the appearance of impropriety. Alabama's arbitration statutes and the American Arbitration Association's AAA commercial arbitration rules, which often govern such proceedings, mandate disclosure of any circumstances that might reasonably lead to a perception of bias. An incorrect approach would be to proceed with the arbitration without disclosing the relationship. This failure to disclose violates the arbitrator's duty of impartiality and transparency. It creates a significant risk that the award could be challenged and vacated on grounds of arbitrator misconduct or bias, as stipulated in Alabama Code Section 6-6-15. Such an action undermines the finality and enforceability of arbitration awards. Another incorrect approach is to disclose the relationship, but proceed with the arbitration without seeking the parties' consent or assessing the impact on impartiality. While disclosure is a step in the right direction, unilaterally deciding to continue when a potential conflict exists, without ensuring that all parties are comfortable and that the arbitrator can remain truly neutral, is insufficient. This approach risks creating an environment where one party feels disadvantaged or that the process is unfair, even if no actual bias occurred. The arbitrator's obligation extends beyond mere disclosure to ensuring that the arbitration remains fair and impartial in appearance and in fact. Finally, an incorrect approach would be to assume the relationship is insignificant and therefore not worth mentioning. This dismissive attitude ignores the fundamental principle that arbitration must be perceived as fair by all participants. Even if the arbitrator genuinely believes the relationship has no bearing on their decision-making, the appearance of bias can be as damaging as actual bias. Alabama law and ethical guidelines require arbitrators to err on the side of caution and disclose any potential conflicts, regardless of their personal assessment of their impact. Professionals should adopt a decision-making framework that prioritizes transparency, impartiality, and adherence to ethical codes. When faced with a potential conflict, the first step is to identify the nature of the relationship and assess its potential to influence or appear to influence the arbitrator's judgment. This assessment should be followed by immediate, written disclosure to all parties. If the disclosure raises concerns, or if the arbitrator cannot confidently maintain impartiality, recusal is the appropriate course of action. This framework ensures that the integrity of the arbitration process is protected, and that parties have confidence in the fairness of the proceedings and the resulting award. Question 11. Risk assessment procedures indicate that a client in an Alabama mediation proceeding has a significantly weaker best alternative to a negotiated agreement BATNA than they initially believe. The mediator, tasked with facilitating a resolution, must advise the client on how to proceed. Which of the following actions best reflects ethical and professional practice in this situation? Option A. Downplay the weaknesses of the client's BATNA to maintain their confidence and encourage them to hold firm on their initial demands. Option B. Urge the client to accept the opposing party's latest offer immediately to avoid further complications, without a detailed exploration of their BATNA. Option C. Focus solely on the perceived weaknesses of the opposing party's BATNA, believing this will naturally lead to a more favorable outcome for the client. Option D. Conduct a thorough and candid discussion with the client about their BATNA, objectively assessing its strengths and weaknesses, and helping them understand how it informs their negotiating position. The correct answer is D. Conduct a thorough and candid discussion with the client about their BATNA, objectively assessing its strengths and weaknesses, and helping them understand how it informs their negotiating position. Explanation. This scenario presents a professional challenge because it requires balancing the duty to represent a client effectively with the ethical obligation to engage in good faith negotiations. The mediator must navigate the client's potentially unrealistic expectations while upholding the principles of fairness and transparency inherent in Alabama's mediation practices. The mediator's role is to facilitate a resolution, not to dictate terms, and this requires careful consideration of the client's BATNA and how it informs their negotiating position. The best approach involves a thorough and candid discussion with the client about their BATNA. This includes objectively assessing the strengths and weaknesses of their alternatives to a negotiated settlement, considering factors such as potential litigation costs, time delays, and the likelihood of success. By helping the client develop a realistic understanding of their BATNA, the mediator empowers them to make informed decisions during the mediation process. This aligns with the ethical duty of competence and diligence, ensuring the client receives adequate representation and understands the implications of their choices. Alabama law and ethical guidelines for mediators emphasize the importance of informed consent and client autonomy, which are directly supported by a clear understanding of the BATNA. An approach that involves withholding or downplaying information about the client's weaker BATNA is ethically problematic. This misleads the client into believing they have a stronger position than they actually do, potentially leading to an impasse in mediation or an agreement that is not in their best long-term interest. Such conduct violates the duty of honesty and could be seen as facilitating a deceptive negotiation strategy, undermining the integrity of the mediation process. Another problematic approach is to ignore the client's BATNA entirely and focus solely on the opposing party's perceived weaknesses. While understanding the other side's position is important, neglecting one's own client's alternatives leaves them unprepared and vulnerable. This demonstrates a lack of diligence and competence, as the mediator is not adequately preparing their client for the realities of negotiation and potential outcomes outside of mediation. Finally, an approach that involves pressuring the client to accept an offer without a clear understanding of their BATNA is also inappropriate. Mediation is a voluntary process, and clients must have the freedom to make decisions based on their own assessment of their alternatives. Coercion or undue influence undermines the client's autonomy and the fundamental principles of fair negotiation. Professionals should approach such situations by first conducting a comprehensive assessment of the client's BATNA, openly discussing the findings with the client, and then collaboratively developing a negotiation strategy based on this realistic understanding. This process ensures the client is empowered, informed, and able to make decisions that align with their best interests, while upholding the ethical standards of mediation. Question 12. The performance metrics show a significant increase in the seller's profit margin on recent equipment sales, but the current negotiation with a potential buyer for a large machinery package is stalled over price. The seller is pushing for their asking price, citing market value, while the buyer expresses concerns about exceeding their project budget. As a mediator in Alabama, how should you best guide this negotiation? Option A. Advise the seller to hold firm on their asking price, emphasizing the market value and the potential for future sales if this deal is secured at their desired profit margin. Option B. Facilitate a discussion to uncover the underlying interests and needs of both the seller and the buyer, exploring creative options beyond the initial price point to find a mutually beneficial solution. Option C. Focus on achieving the seller's profit margin target, suggesting the buyer explore financing options to meet the seller's price, even if it strains their immediate budget. Option D. Present the seller's asking price as a final offer and encourage the buyer to accept it to avoid further delays and potential loss of the equipment. The correct answer is B. Facilitate a discussion to uncover the underlying interests and needs of both the seller and the buyer, exploring creative options beyond the initial price point to find a mutually beneficial solution. Explanation. This scenario presents a professional challenge because it pits the immediate financial interests of the seller against the long-term relationship and potential for future business with the buyer. The mediator must navigate these competing interests ethically and effectively, adhering to the principles of Alabama's mediation practice. The best approach in this situation is to facilitate an integrative negotiation. This involves exploring the underlying interests of both parties beyond the stated price. The seller's interest might be in a quick sale and minimizing storage costs, while the buyer's interest might be in acquiring the equipment for a specific project with a tight deadline, or perhaps in the seller's expertise. By focusing on these deeper needs, the mediator can help the parties identify creative solutions that satisfy both parties, such as a phased payment plan, inclusion of training, or a commitment for future service contracts. This aligns with the ethical duty of a mediator in Alabama to remain neutral and to assist parties in reaching a mutually acceptable agreement, fostering a collaborative environment rather than an adversarial one. Alabama law emphasizes the voluntary nature of mediation and the parties' autonomy to craft their own solutions, which is best achieved through integrative strategies. An approach focused solely on maximizing the seller's immediate profit, without considering the buyer's constraints or underlying needs, is problematic. This distributive approach, where one party's gain is perceived as the other's loss, can lead to an impasse or an agreement that is unsustainable for the buyer, potentially damaging the mediator's reputation and the integrity of the mediation process. Risks violating the spirit of collaborative problem-solving that Alabama mediation aims to achieve. Another less effective approach would be to simply present the seller's initial offer as a take-it-or-leave-it proposition. This is a purely distributive tactic that ignores the potential for mutual gain and fails to explore the buyer's perspective or underlying interests. It can be perceived as directive rather than facilitative, undermining the parties' autonomy and their ability to reach a truly satisfactory agreement. Finally, pressuring the buyer to accept an offer that clearly exceeds their budget, even if it meets the seller's minimum, is unethical and counterproductive. This disregards the buyer's financial realities and the principle of informed consent in reaching an agreement. Such pressure can lead to a coerced agreement, which is not a genuine resolution, and can result in future disputes or dissatisfaction. Professionals should approach such situations by first understanding the stated positions and then probing for underlying interests. This involves active listening, asking open-ended questions, and reframing issues to encourage creative problem-solving. The mediator's role is to facilitate communication and exploration, not to dictate terms, ensuring that any agreement reached is voluntary, informed, and sustainable for all parties involved, in accordance with Alabama's mediation guidelines. Question 13. The efficiency study reveals that during a mediation session in Alabama concerning a property dispute, one party appears to have a significant misunderstanding of a key factual detail regarding the property's boundary lines, a misunderstanding that, if corrected, would substantially weaken their negotiating position. As the mediator, what is the most ethically sound and professionally responsible course of action? Option A. Gently and neutrally inquire with both parties to ensure a shared understanding of the relevant factual details, without revealing who holds the misunderstanding. Option B. Subtly steer the conversation to capitalize on the opposing party's factual misunderstanding to secure a more favorable outcome for your client. Option C. Ignore the factual discrepancy and proceed with the negotiation, allowing the parties to reach an agreement based on their current understanding. Option D. Inform your client of the opposing party's misunderstanding and collaborate on a strategy to exploit this during the negotiation, without disclosing it to the other party. The correct answer is A. Gently and neutrally inquire with both parties to ensure a shared understanding of the relevant factual details, without revealing who holds the misunderstanding. Explanation. This scenario presents a professional challenge because it requires balancing the pursuit of a favorable outcome for a client with the ethical obligation to engage in fair and honest negotiation. The mediator must navigate the temptation to exploit a perceived weakness in the opposing party's position, while upholding the principles of integrity and transparency inherent in the Alabama mediation process. The core of the challenge lies in distinguishing between legitimate negotiation strategy and unethical manipulation. The best approach involves a mediator who, upon recognizing the opposing party's potential misunderstanding of a critical fact, gently and neutrally seeks clarification from both sides. This approach is correct because it aligns with the ethical guidelines for mediators in Alabama, which emphasize impartiality, fairness, and the promotion of informed decision-making. By facilitating a shared understanding of the facts, the mediator upholds their duty to ensure the negotiation process is not based on misinformation or deception. This promotes a more sustainable and ethical resolution. An incorrect approach involves the mediator exploiting the opposing party's misunderstanding by subtly guiding the conversation to favor their client's position without correcting the factual error. This is ethically problematic as it violates the principle of impartiality and can lead to an unfair outcome. It also undermines the integrity of the mediation process, potentially leading to future disputes if the true facts are later revealed. Another incorrect approach is for the mediator to directly inform their client about the opposing party's misunderstanding and strategize with them on how to leverage this information, without disclosing it to the other party. This creates a conflict of interest and compromises the mediator's neutral role. It transforms the mediator into an advocate for one party, which is contrary to the fundamental tenets of mediation ethics in Alabama. Finally, an incorrect approach would be for the mediator to ignore the factual discrepancy altogether and proceed with the negotiation as if the misunderstanding did not exist. While seemingly neutral, this passive approach allows the negotiation to proceed on a flawed premise, which can still lead to an unfair or unsustainable agreement. It fails to actively promote a process where both parties are operating with accurate information. Professionals should employ a decision-making framework that prioritizes ethical conduct and the integrity of the process. This involves a continuous self-assessment of one's actions and motivations, ensuring they align with established ethical codes and legal requirements. When faced with a situation where one party may be misinformed, The professional mediator should consider how to best facilitate clarity and understanding for all participants, rather than seeking to gain an advantage through deception or omission. The goal is to empower parties to make informed decisions, not to manipulate them into agreements. Question 14. The control framework reveals that during a mediation session in Alabama concerning a contentious property dispute, one party becomes visibly distressed and begins to express anger and frustration, stating they feel unfairly treated and are unwilling to consider any settlement that does not fully align with their perceived rights, which are based on an emotional interpretation of past events. How should the mediator best manage this situation to facilitate a productive negotiation? Option A. Acknowledge the parties' feelings of frustration and anger, validate that they are experiencing these emotions, and then gently redirect the conversation back to the objective issues and the process of finding a mutually agreeable solution. Option B. Mirror the parties' emotional intensity by expressing similar frustration and anger to demonstrate solidarity and understanding of their perceived injustice. Option C. Immediately adjourn the mediation session, suggesting that the parties cool down separately and reconvene at a later date without further discussion of the emotional outburst. Option D. Advise the party that their emotional response is hindering the negotiation and that they need to suppress their feelings to proceed rationally. The correct answer is A. Acknowledge the parties' feelings of frustration and anger, validate that they are experiencing these emotions, and then gently redirect the conversation back to the objective issues and the process of finding a mutually agreeable solution. Explanation. The control framework reveals that managing emotions in negotiation is a critical aspect of effective dispute resolution in Alabama. This scenario is professionally challenging because the mediator must navigate the intense emotional state of one party without allowing it to derail the negotiation process or compromise the integrity of the mediation. The mediator's primary duty is to facilitate a voluntary agreement, and unchecked emotions can create significant barriers to productive dialogue and rational decision-making, potentially leading to an impasse or an unfair outcome. The best approach involves acknowledging the parties' emotions without validating potentially unreasonable demands stemming from those emotions. This means actively listening, empathizing with the expressed feelings, and gently redirecting the conversation back to the objective issues and potential solutions. The mediator should validate the feeling. I understand you are feeling frustrated, but not necessarily the reason for the feeling if it is factually inaccurate or legally unfounded. This approach aligns with the ethical guidelines for mediators in Alabama, which emphasize impartiality, self-determination of the parties, and the facilitation of a fair process. By maintaining a calm, neutral demeanor and focusing on the process, the mediator helps de-escalate the situation and encourages the parties to engage in constructive problem-solving, respecting the parties' right to reach their own agreement. An approach that involves mirroring the emotional intensity of the party is professionally unacceptable. This would compromise the mediator's neutrality and could be perceived as taking sides, thereby alienating the other party and undermining the entire mediation process. Such a response violates the core principle of impartiality required of mediators in Alabama. Another unacceptable approach is to dismiss or minimize the parties' emotions. While the mediator's role is not to be a therapist, ignoring or downplaying significant emotional distress can shut down communication, make the party feel unheard, and prevent them from engaging in the negotiation. This failure to acknowledge the human element of the dispute can lead to a breakdown in trust and a lack of commitment to any potential agreement. Furthermore, an approach that involves lecturing the party on the irrationality of their emotions is also professionally unsound. While the mediator may observe irrationality, direct confrontation of this nature is likely to be counterproductive, leading to defensiveness and further entrenchment of the party's position. This can hinder the mediator's ability to facilitate a resolution and may violate the principle of respecting the party's dignity. Professionals should employ a decision-making framework that prioritizes active listening, empathy, and neutrality. When faced with strong emotions, the mediator should first acknowledge and validate the emotion without necessarily agreeing with its cause or the demands it fuels. The mediator should then gently guide the conversation back to the issues at hand, focusing on interests and potential solutions rather than solely on positions driven by emotion. This involves maintaining a calm and controlled demeanor, using open-ended questions to encourage dialogue, and periodically summarizing progress to reinforce constructive engagement. The ultimate goal is to help the parties manage their emotions sufficiently to engage in a productive negotiation process that respects their self-determination and leads to a mutually acceptable resolution, in accordance with Alabama's mediation standards. Question 15. The control framework reveals that in a conciliation proceeding in Alabama, a conciliator is facilitating a dispute between two business partners. One partner is highly emotional and expresses significant anger and frustration, repeatedly interrupting the other partner and making accusatory statements. The other partner appears withdrawn and hesitant to speak. What is the most appropriate course of action for the conciliator to maintain the integrity of the conciliation process? Option A. Acknowledge the emotional expressions of the angry partner, validate their feelings without agreeing with the accusations, and then gently redirect the conversation back to identifying specific issues and exploring potential solutions, while also encouraging the withdrawn partner to share their perspective. Option B. Advise the angry partner that their behavior is disruptive and that if it continues, the conciliation will be terminated, without further attempt to understand or manage their emotional state. Option C. Focus solely on de-escalating the emotional partner's anger by spending a significant amount of time listening to their grievances, even if it means neglecting the other partner's opportunity to speak. Option D. Offer a proposed resolution to the dispute, suggesting terms that the conciliator believes are fair based on the information presented, to quickly end the tense situation. The correct answer is A. Acknowledge the emotional expressions of the angry partner, validate their feelings without agreeing with the accusations, and then gently redirect the conversation back to identifying specific issues and exploring potential solutions, while also encouraging the withdrawn partner to share their perspective. Explanation. The control framework reveals that conciliation in Alabama, governed by the Alabama Rules of Civil Procedure and relevant statutes, requires a neutral facilitator to assist parties in reaching a mutually agreeable resolution. The professional challenge in this scenario lies in maintaining impartiality while guiding parties toward a resolution, especially when one party exhibits resistance or emotional distress. A conciliator must navigate these dynamics without imposing a solution or taking sides, adhering strictly to the principles of voluntary participation and party self-determination. The best approach involves the conciliator actively listening to both parties, acknowledging their perspectives and emotions without validating or invalidating them, and then facilitating a structured discussion focused on identifying underlying interests and potential areas of compromise. This approach is correct because it aligns with the core tenets of conciliation as a facilitative process, emphasizing party autonomy and a non-adjudicatory role for the conciliator. Alabama law and ethical guidelines for mediators and conciliators stress the importance of neutrality and the conciliator's role in managing the process, not dictating the outcome. By focusing on interests and exploring options collaboratively, the conciliator empowers the parties to craft their own agreement, which is more likely to be sustainable. An incorrect approach would be for the conciliator to offer a suggested settlement based on their assessment of the legal merits of the case. This fails because it moves the conciliator from a neutral facilitator to an adjudicator or advisor, undermining party self-determination and potentially creating a perception of bias. Conciliators are not authorized to provide legal advice or impose solutions. Their role is to help parties communicate and explore their own solutions. Another incorrect approach would be for the conciliator to become overly involved in managing the emotional outbursts of one party to the detriment of the other, perhaps by spending an excessive amount of time attempting to pacify them, or by allowing their distress to derail the structured discussion. This is professionally unacceptable as it compromises neutrality and fairness. While managing emotions is part of the process, it must be done in a way that ensures both parties feel heard and respected, and that the conciliation process remains balanced and productive for both. The conciliator's duty is to manage the process equitably, not to act as a therapist or to prioritize one party's emotional state over the progress of the conciliation for both. The professional decision-making process for similar situations should involve a constant self-assessment of neutrality, a clear understanding of the conciliator's role as a process manager, and a commitment to empowering parties to reach their own agreements. When faced with challenging dynamics, The conciliator should refer back to the foundational principles of conciliation and relevant Alabama procedural rules, focusing on maintaining a safe and productive environment for communication and negotiation. Question 16. The control framework reveals that during a mediation session in Alabama concerning a contentious property dispute, one party, Ms. Evans, begins to exhibit significant emotional distress, including tearfulness and difficulty articulating her thoughts clearly. As the mediator, what is the most ethically sound and procedurally appropriate course of action to ensure the integrity of the mediation process? Option A. Gently inquire about Ms. Evans' current capacity to participate effectively, offering a break or the option to reschedule if she feels unable to proceed constructively. Option B. Encourage Ms. Evans to push through her emotions, explaining that emotional responses are common in disputes and that continuing is necessary for resolution. Option C. Offer Ms. Evans personal advice and reassurance, attempting to counsel her through her emotional distress to help her re-engage in the discussion. Option D. Continue with the mediation session, focusing on the legal aspects of the property dispute to maintain momentum and avoid delaying the process. Correct answer is A. Gently inquire about Ms. Evans' current capacity to participate effectively, offering a break or the option to reschedule if she feels unable to proceed constructively. Explanation. This scenario presents a professional challenge because the mediator must navigate a situation where a party's emotional state could impede their ability to engage constructively in the ADR process, potentially leading to an unfair or incomplete resolution. The mediator's duty is to facilitate a fair and voluntary process, ensuring all parties have the capacity to participate meaningfully. Alabama law and ethical guidelines for mediators emphasize neutrality, impartiality, and the promotion of informed consent. The best approach involves the mediator acknowledging the party's distress and gently exploring their capacity to participate effectively in the current session. This includes inquiring about their understanding of the process, their ability to make decisions, and whether they feel ready to proceed. If the party expresses a desire to pause or seek support, the mediator should facilitate this, perhaps by suggesting a break, rescheduling, or recommending they consult with a trusted advisor or professional. This aligns with the mediator's ethical obligation to ensure the process is voluntary and that parties are not coerced or unduly influenced by their emotional state. Alabama Code Section 6-6-33 states that mediation aims for voluntary settlement, implying that parties must be capable of voluntary participation. Furthermore, ethical standards for mediators in Alabama often mirror those of the Association for Conflict Resolution, which stress the mediator's responsibility to ensure parties understand the process and are able to make informed decisions. An incorrect approach would be to ignore the party's visible distress and proceed with the mediation as if nothing is amiss. This fails to uphold the mediator's duty of care and impartiality, as the distressed party may not be able to articulate their needs or interests effectively, leading to a resolution that is not truly voluntary or in their best interest. This could violate the principle of informed consent, a cornerstone of ADR. Another incorrect approach is for the mediator to offer personal advice or attempt to counsel the distressed party. Mediators are facilitators, not therapists or legal advisors. Offering personal opinions or attempting to resolve the underlying emotional issues goes beyond the mediator's role and compromises their neutrality, potentially creating a conflict of interest and undermining the integrity of the mediation process. This violates the ethical principle of impartiality and the prohibition against providing legal or therapeutic advice. Finally, an incorrect approach would be to pressure the distressed party to continue with the mediation, suggesting that their emotional state is an impediment to progress. This coercive tactic disregards the party's well-being and their right to participate in a process where they feel capable of making decisions. It undermines the voluntary nature of mediation and could lead to a settlement that is later regretted or challenged. Professionals should employ a decision-making framework that prioritizes party capacity and the integrity of the ADR process. This involves 1. Active observation and assessment of party demeanor and communication. 2. Gentle inquiry to understand the impact of any observed issues on participation. 3. Offering appropriate procedural adjustments, e.g., breaks, rescheduling, or recommending external support if necessary, while maintaining strict neutrality. 4. ensuring that any decision to proceed or pause is based on the parties' informed consent and capacity to engage. Question 17. What factors determine the most effective mediation approach when mediating disputes arising in Alabama, considering the distinct legal and interpersonal dynamics inherent in family, commercial, and employment law matters? Option A. Adapting mediation techniques and process based on the specific legal framework, typical power dynamics, and common emotional considerations relevant to family, commercial, or employment disputes within Alabama. Option B. Prioritizing the mediator's personal experience and preferred mediation style over the specific legal and contextual nuances of each dispute type. Option C. Applying a standardized, one-size-fits-all mediation process regardless of the dispute type, focusing solely on general conflict resolution principles. Option D. Focusing exclusively on the financial aspects of the dispute, assuming all parties are primarily motivated by monetary gain, irrespective of the dispute's origin. The correct answer is A. Adapting mediation techniques and process based on the specific legal framework, typical power dynamics, and common emotional considerations relevant to family, commercial, or employment disputes within Alabama. Explanation. This scenario is professionally challenging because the mediator must navigate the distinct legal and emotional landscapes of family, commercial, and employment disputes, each governed by specific Alabama laws and ethical considerations for mediators. The Alabama Mediation Rules and the Alabama Center for Dispute Resolution's Code of Professional Conduct provide the overarching framework, but the application requires nuanced judgment based on the context. The best approach involves tailoring the mediation process and the mediator's style to the specific context of the dispute, while adhering to core mediation principles. This means understanding the unique power dynamics, communication patterns, and legal frameworks relevant to family law e.g. Alabama Rules of Civil Procedure concerning domestic relations, child support guidelines, commercial law e.g. Alabama Contract Code, Uniform Commercial Code, and employment law e.g. Alabama Minimum Wage Act, Title VII of the Civil Rights Act as applied in Alabama. A mediator must be prepared to address issues of emotional intensity in family cases, financial and contractual complexities in commercial disputes, and statutory rights and employer policies in employment matters. This contextual awareness ensures that the mediation is conducted in a manner that is both procedurally fair and substantively relevant to the parties' concerns and legal realities within Alabama. An approach that fails to differentiate between dispute types is professionally unacceptable. For instance, applying the same direct, evaluative style suitable for some commercial disputes to a highly emotional family dispute involving child custody could be detrimental, potentially exacerbating conflict and undermining trust. Similarly, ignoring specific statutory rights or employer policies in an employment mediation, or failing to acknowledge the unique legal framework for child support and property division in a family case, would violate the mediator's duty to facilitate a process that is informed by the relevant legal context in Alabama. Over-reliance on a single mediation model, without considering the specific legal and relational dynamics of each context, risks creating an environment where parties feel unheard, misunderstood, or that their legal rights are being disregarded, thereby failing to uphold the integrity of the mediation process, as envisioned by Alabama's ADR framework. Professionals should employ a decision-making framework that begins with a thorough intake process to understand the nature of the dispute and the parties' objectives. This should be followed by an assessment of the relevant legal and ethical considerations specific to Alabama for that type of dispute. The mediator should then select and adapt mediation techniques that are most appropriate for the identified context, ensuring neutrality, confidentiality, and voluntariness are maintained throughout the process, in accordance with Alabama mediation rules and ethical standards. Question 18. The control framework reveals that during a mediation session in Alabama concerning a property dispute, one party, without prior disclosure, presents a newly discovered survey that significantly alters the perceived boundary lines in favor of their position. The other party appears visibly distressed and confused by this new information. What is the most appropriate course of action for the mediator? Option A. Advise the party presenting the survey to withdraw it from consideration, as it was not previously disclosed and appears to be causing distress. Option B. Accept the survey as evidence and allow the mediation to continue, assuming the parties will naturally address its significance. Option C. Inform the distressed party that they can choose to end the mediation if they feel overwhelmed by the new information. Option D. Facilitate a discussion between the parties about the new survey, its implications, and how they wish to proceed with this information in their negotiations, ensuring both parties understand its potential impact. The correct answer is D. Facilitate a discussion between the parties about the new survey, its implications, and how they wish to proceed with this information in their negotiations, ensuring both parties understand its potential impact. Explanation. This scenario presents a professional challenge because the mediator must navigate the delicate balance between facilitating open communication and ensuring the integrity of the mediation process, particularly when one party attempts to introduce information that is both legally significant and potentially prejudicial to the other party's understanding of their rights. The mediator's duty is to remain neutral and impartial, guiding the parties towards a voluntary resolution without imposing their own judgment or influencing the outcome. Careful judgment is required to uphold these core principles, while effectively managing the flow of information and the parties' emotional states. The best approach involves the mediator acknowledging the information presented, clarifying its relevance and potential impact with the parties, and then empowering the parties to decide how to proceed with that information. This approach aligns with the fundamental principles of mediation, emphasizing party self-determination and informed consent. By facilitating a discussion about the information's significance and allowing the parties to collectively determine its role in their negotiations, the mediator upholds neutrality and respects the parties' autonomy. This is ethically sound and consistent with the spirit of Alabama's mediation guidelines, which prioritize voluntary settlement and party control over the process and outcome. An incorrect approach would be for the mediator to unilaterally decide to exclude the information without consulting the parties. This action oversteps the mediator's role by making a substantive decision about the case's merits, thereby compromising neutrality and potentially undermining party self-determination. It suggests the mediator is taking a position on the relevance or weight of the evidence, which is inappropriate. Another incorrect approach would be for the mediator to accept the information without any discussion or clarification, allowing it to potentially influence the other party's perception of their position without adequate understanding or opportunity to respond. This failure to ensure informed consent and to manage the flow of potentially prejudicial information violates the mediator's duty to facilitate a fair and balanced process. A further incorrect approach would be for the mediator to pressure the party presenting the information to withdraw it. This is a direct violation of neutrality and party self-determination, as the mediator is actively trying to shape the negotiation by removing certain elements, rather than allowing the parties to decide what is important to them. Professionals should employ a decision-making framework that prioritizes neutrality, impartiality, party self-determination, and informed consent. When faced with new or potentially sensitive information, the mediator should first seek to understand its nature and relevance. Then, they should facilitate a discussion among the parties about how this information should be handled, ensuring all parties have an opportunity to understand its implications and agree on its inclusion or exclusion from the mediation process. The mediator's role is to guide the process, not to dictate its content or outcome. Question 19. The control framework reveals that during a mediation session in Alabama, one party expresses significant reservations about the process, stating they feel pressured to settle. As the mediator, what is the most ethically sound and legally compliant course of action to uphold the principles of alternative dispute resolution in Alabama? Option A. Continue with the mediation as planned, assuming the party will eventually become more comfortable and agree to participate fully. Option B. Reiterate that mediation is a voluntary process and offer to pause the session or proceed at a pace comfortable for the party, ensuring they understand they can stop at any time. Option C. Subtly emphasize the time and resources already invested in the mediation to encourage the party to continue and reach a resolution. Option D. Advise the party to immediately seek legal counsel before continuing with the mediation session. Correct answer is B. Reiterate that mediation is a voluntary process and offer to pause the session or proceed at a pace comfortable for the party, ensuring they understand they can stop at any time. Explanation. The control framework reveals a common challenge in Alabama's legal landscape, navigating the appropriate use of ADR when a party expresses reservations. A mediator must exercise careful judgment to ensure the process remains voluntary and fair, respecting the parties' autonomy while still facilitating a potential resolution. The professional challenge lies in balancing the mediator's duty to encourage settlement with the absolute requirement that participation in ADR, particularly mediation, is consensual. The best approach involves clearly reiterating the voluntary nature of mediation and offering to pause or terminate the session if the party feels unduly pressured. This aligns with the fundamental ethical principles of mediation, which emphasize party self-determination and the mediator's neutrality. Alabama law and mediation best practices underscore that a mediator cannot compel participation or agreement. By offering to stop or continue at the party's pace, the mediator upholds the integrity of the process and respects the individual's right to withdraw or proceed with caution, thereby maintaining trust and ensuring the process is not coercive. An approach that involves subtly pressuring the party by emphasizing the time and cost already invested is professionally unacceptable. This tactic undermines the voluntary nature of mediation and can be perceived as coercive, violating the principle of party self-determination. It creates an environment where a party might feel obligated to continue against their genuine wishes, leading to an unfair or unenforceable outcome. Another professionally unacceptable approach is to proceed with the mediation as if no reservations were expressed, assuming the party will eventually acquiesce. This demonstrates a failure to actively listen and respond to a party's expressed concerns. It disregards the ethical duty of a mediator to ensure all parties are comfortable and willing participants, potentially leading to a breakdown of trust and the perception of an unfair process. Finally, an approach that involves suggesting the party consult with their attorney before continuing, without first addressing the expressed reservations directly, is also problematic. While encouraging legal counsel is often appropriate, in this specific instance, it bypasses the mediator's immediate responsibility to ensure the party's comfort and willingness to proceed with the mediation itself. The primary ethical obligation is to address the expressed reservations about the process first, before suggesting external consultation as the sole solution. Professionals should employ a decision-making framework that prioritizes active listening, clear communication of rights and responsibilities, and a commitment to party self-determination. When a party expresses reservations, the mediator's first step should be to acknowledge and address those concerns directly, reaffirming the voluntary nature of the process and offering flexibility. Question 20. Strategic planning requires a thorough assessment of potential legal outcomes. In Alabama, a consumer enters into a contract containing an arbitration clause. The arbitration clause stipulates that all disputes will be resolved through arbitration administered by a specific arbitration provider. The provider's standard fee schedule indicates that the arbitrator's fees for a case of this nature are estimated to be $3,000, with each party responsible for half of this amount, $1,500. The consumer's potential claim for damages is estimated to be $2,500. Based on these figures, what is the most appropriate assessment of the enforceability of the arbitration clause from a cost perspective under Alabama law? Option A. The arbitration clause is unenforceable solely because the total estimated arbitrator fees, $3,000, exceed the potential claim value, $2,500. Option B. The arbitration clause is enforceable because the fee schedule is set by an independent arbitration provider, and the consumer agreed to abide by its rules. Option C. The arbitration clause is likely unenforceable because the estimated arbitrator fees, $1,500, represent a substantial portion of the potential claim value, $2,500, potentially creating a prohibitive barrier to access to justice for the consumer. Option D. The arbitration clause is enforceable because arbitration is generally favored by Alabama law, and the consumer signed the agreement. The correct answer is C. The arbitration clause is likely unenforceable because the estimated arbitrator fees, $1,500, represent a substantial portion of the potential claim value, $2,500, potentially creating a prohibitive barrier to access to justice for the consumer. Explanation. This scenario presents a professional challenge because it requires balancing the enforceability of an arbitration agreement with the potential for an unfair outcome due to a poorly drafted clause. Alabama law, like many jurisdictions, favors the enforcement of arbitration agreements, but this preference is not absolute and can be overcome by unconscionability or fundamental unfairness in the drafting. The core of the challenge lies in determining whether the financial implications of the arbitration clause, as calculated, render it unenforceable under Alabama's contract law principles, particularly regarding fairness and mutual assent. Careful judgment is required to assess the financial burden and its potential impact on the parties' ability to pursue their claims. The best approach involves a precise calculation of the potential costs associated with arbitration, specifically focusing on the arbitrator's fees and comparing these to the potential recovery. If the estimated arbitrator fees alone exceed a reasonable proportion of the likely damages, or if they create a prohibitive barrier to access to justice for one party, the clause may be deemed substantively unconscionable. This approach is correct because it directly addresses the financial realities of the arbitration process and aligns with Alabama's judicial scrutiny of arbitration clauses for fairness and enforceability, particularly in consumer or employment contexts where there's a power imbalance. Alabama courts will examine whether the costs imposed by the arbitration agreement are so excessive as to effectively deny a party their day in court. An approach that focuses solely on the existence of a signed arbitration agreement, without considering the financial implications of its terms, is professionally unacceptable. This overlooks the Alabama Supreme Court's precedent that arbitration agreements, while favored, are still subject to contract defenses, including unconscionability. Ignoring the cost factor fails to acknowledge that an agreement can be procedurally sound, e.g., signed willingly, but substantively unfair due to prohibitive costs. Another professionally unacceptable approach is to assume enforceability simply because arbitration is generally encouraged by statute. This disregards the critical caveat that enforceability is contingent upon the fairness of the terms. An arbitration clause that imposes costs so high that they effectively preclude a party from seeking redress is not enforceable, regardless of general statutory preference. Finally, an approach that prioritizes the arbitration provider's fee schedule without considering the specific context of the dispute and the party's financial capacities is flawed. While fee schedules are standard, their application must be evaluated against the backdrop of the potential claims and the ability of the parties to bear such costs. A rigid adherence to a fee schedule without this contextual analysis can lead to an unconscionable outcome. Professionals should employ a decision-making framework that begins with confirming the existence and validity of the arbitration agreement. Subsequently, they must meticulously analyze the specific terms of the agreement, with a particular focus on any cost-sharing provisions or arbitrator fee structures. This analysis should involve calculating the potential financial burden on each party, especially the party with potentially weaker bargaining power. This calculation should then be compared against the potential value of the claims and the overall fairness of the process. If the calculated costs appear prohibitive or disproportionate, further investigation into the enforceability of the clause under Alabama's unconscionability doctrines is warranted. This systematic approach ensures that both the intent to arbitrate and the principles of fairness and access to justice are respected.